Russia has invaded Ukraine, and many are calling this an illegal war of aggression. But what does it mean for a war to be illegal? What does international law mean in this context? And what is even international law itself? Because the recent Russian invasion of Ukraine has shocked and horrified people all around the world. Almost every nation has condemned the invasion, many calling it an illegal war. Even traditionally neutral countries like Switzerland and Sweden have joined in economic sanctions against Russia. And the Secretary General of the United Nations concluded that Russia's invasion of Ukraine violated international law, saying, quote, "It is wrong, it is against the United Nations Charter, it is unacceptable." The United Nations Charter, which has been affirmed by 193 member states, says that countries should not invade each other. But what happens next comes down to this. Who, if anyone, has the authority to enforce international law? And how are you going to stop an invading force? Law professor Louis Henkin, who is credited with founding the study of human rights law, famously wrote that, quote, "Almost all nations observe almost all principles of international law and almost all of their obligations almost all the time." Henkin's observation was that in the modern world, most countries agree on the general standards of international conduct. However, the troubles arise because of the word almost. What about when nations don't agree with international standards of conduct, or just simply don't observe them? Do these international standards have the force of law? Does the international community have the ability to enforce its standards of conduct? Well, today we're going to talk about international law, what it is, what it isn't, and what happens next in Ukraine. But first, some background on Russian and Ukrainian history. Now, this is a very complicated subject. I'm only going to scratch the surface, but I think this will be helpful. From 1922 until 1991, Ukraine was a member of the Soviet Union. But in 1991, it declared its independence and became its own sovereign state. In 2004, the Orange Revolution led to annulling a presidential election, which was claimed to be marred by massive corruption, voter intimidation, and electoral fraud. New elections were held in 2005 that eventually led to Viktor Yushchenko beating the Russian-backed Viktor Yanukovych. But Yanukovych eventually succeeded in the 2010 election. But in 2013, the Ukrainian people launched a protest movement against the corrupt pro-Russian president Viktor Yanukovych, who was seen as being backed by Russian billionaires who were hostile to NATO. Not to make this about the United States, but coincidentally, during this era, Donald Trump's campaign manager, Paul Manafort, spent 10 years as one of Yanukovych's advisors. Of course, in 2020, President Trump was impeached by the House after he put on hold $391 million in congressionally approved military aid to Ukraine. But in 2013, Ukraine's government was about to sign an agreement establishing closer ties with Europe, but Yanukovych backed out 1 week before the agreement was to be signed. Instead, he announced that Ukraine would build a stronger relationship with Russia. This announcement reneged on a campaign promise, and Yanukovych's popularity plummeted. And after the Euromaidan protests, Yanukovych fled to Russia, and Ukraine elected a pro-Western government. And in 2014, Russia tried to hack Ukraine's Central Election Commission so that it would present a far-right candidate who, in fact, got less than 1% of the vote as the winner. As historian Tim Snyder documented, the hack failed, but Russian media had been prepared for its success, and Russian television went on air with falsified documents, even digital images that matched what the hack was supposed to produce. When the election gambit failed, Russia invaded Ukraine and annexed the territory of Crimea. And in 2019, former comedian Volodymyr Zelensky, who on TV played a history teacher who ran on an anti-corruption platform and eventually became the president of Ukraine, ran on an anti-corruption platform and became the president of Ukraine. And of course, prior to this most recent invasion, Zelensky was famous in the United States for having what everyone called a perfect phone call with former President Donald Trump. Just an absolutely perfect phone call. Then in February of 2022, Russian President Vladimir Putin launched a full-scale war on Ukraine, claiming that he needed to eliminate Nazism in Ukraine and that he was defending the people of the Donbas regions of Ukraine. The international community recognized that Donbas, like Crimea, is part of Ukraine. So the question is this an illegal war? And what does it even mean to be an illegal war under international law? Well, I'm sorry to tell you, it probably doesn't mean all that much. So the phrase international law is a bit of a misnomer because international law isn't really binding in the way that American laws generally are. In America, the primary sources of law are the US Constitution, laws enacted by Congress, rules promulgated by federal agencies, state constitutions, laws enacted by state legislatures, rules promulgated by state agencies, and city or county charters and local laws. And as you can see, there's generally a hierarchy to these laws. Statutes and rules can't contradict a higher source of law. For example, the US Constitution is generally at the top of that list, and a state law or a state constitution that contradicts the federal constitution, where state law is supreme, is considered void. But in contrast, there isn't really an international hierarchy of law. Sovereign nations may agree on general principles of conduct, but there isn't a body of international law that is superior to their own national laws. So the first thing you need to know about international law is that everything is dependent on the individual states. And as you can imagine, individual sovereign nations are incredibly reluctant to give up any of their autonomy and to subject themselves to the potential whims of other countries. The United States is no exception to this. So what do we mean when we talk about international law? Well, the most important sources of international law are customary international law derived from practice of the states, treaties between the states, and general principles of law recognized by civilized nations. Now, the oldest source of what we call international law tends to be customary international law. And this doesn't really have a written source, like a criminal code. Instead, it's more like English common law, since it's made up of unwritten rules that are derived from custom and practice. A rule of customary law has two elements. First, there has to be widespread and consistent state practice. The practice must be by the government, but must also be recognized by the state's courts and parliaments. And second, there has to be what's called opinio juris, which is the state's belief that it has a legal obligation. What's an example of customary international law? Well, diplomatic immunity, for example. Diplomatic immunity is a principle that gives certain foreign government officials the right to safe passage through other countries, guaranteeing the diplomat cannot be sued or arrested for violating the host country's law. This principle of diplomatic immunity is one of the oldest elements of foreign relations, observed in ancient Greece and Rome, sometimes. Now, prior to World War II, countries recognized diplomatic immunity based simply on precedent. But after World War II, diplomatic immunity was embedded in a number of international conventions. And today, all countries agree that diplomats have diplomatic immunity, although they can be expelled from their host countries for violating the law. Then we can talk about treaties. Treaties are a second source of international law. An international treaty is a written agreement between international law subjects reflecting their consent to the creation, alteration, or termination of their rights and obligations. Treaties may also be called agreements, conventions, or protocols. Now, a treaty is not the same thing as a law. A treaty is a source of an obligation under the law, and treaties are only binding on states which agree to become parties to them. So there is no international tribunal or government that can force any sovereign nation to become a party to a treaty against that nation's will. And so if there's no government or court that can compel states to join or comply with a treaty, why are treaties binding at all? Well, generally because of a customary principle of international law called pacta sunt servanda, which is Latin for agreements must be kept. And I greatly apologize for all of my mispronounced Latin throughout this entire video. As it turns out, it's really hard to speak a dead language. Now, all states recognize that they are bound by the agreements that they make, and therefore they are obligated to honor their treaties. But sometimes a treaty will memorialize a principle of customary law, in essence codifying a general understanding between nations. For example, the 1969 Vienna Convention on the Law of Treaties codified the basic customary principles governing international treaties. The Vienna Convention is known as the Treaty on Treaty. And in the US, for example, a treaty only becomes binding if Congress agrees that it should become binding and effectively the law of the United States. So again, it's about the consent of the governed, and if a country wants to back out of a treaty, there's effectively nothing that any other country can do. But then that takes us to general principles of civilized nations. These are general principles of fairness and justice, which are applied universally in legal systems around the world. And although that sounds pretty sweeping, in reality, these principles are pretty much gap fillers. When there's a dispute and there is no provision in an international treaty or statute or any recognized customary principle of international law, the general principles of law can be used to fill the gaps. An example of that would be the admission of indirect evidence. In 1949, an International Court of Justice decision addressed whether Albania had civil liability for the mining of the Corfu Channel and subsequent damage to 2 British naval vessels. The court ruled that the UK could establish the knowledge and responsibility of Albania for laying mines in the water through indirect evidence, since indirect evidence is admitted in basically all systems of law. And then, of course, there are other sort of miscellaneous sources of international law that may help resolve international disputes. You can look to court decisions, writings by international lawyers, and actions taken by the United Nations and its many organs. But you can imagine that if the prior sources of international law aren't binding, these certainly are not going to have that much of a precedential effect. Now, I'm sure many people are watching this video and screaming at the screen, what about the United Nations? Well, the United Nations was established after World War II to provide a formal way for nations of the world to communicate and resolve disputes. The Charter of the United Nations is an international treaty that commits member states to settle their disputes by peaceful means. Many people have the mistaken impression, though, that the UN General Assembly is the government of the whole world. However, the United Nations General Assembly has no power to legislate for the international community. Its resolutions are not legally binding. The General Assembly cannot enact international laws and then force member states to submit to its authority. UN resolutions do influence international relations, but they're not the equivalent of laws and statutes. So that's the United Nations General Assembly, but what about the UN Security Council? And in fact, the UN Security Council is the only international body that has the power to make binding decisions on all nations. The council has 15 members. The 5 permanent members are China, France, Russia, the United Kingdom, and the United States. And it also has 10 non-permanent members whose terms run for 2 years. Each member has 1 vote. And in 2022, the temporary members of the Security Council are the United Arab Emirates, Albania, Brazil, Gabon, Ghana, India, Ireland, Kenya, Mexico, and Norway. The 5 permanent members all have veto power over all UN Security Council matters. And under the Charter of the United Nations, all member states are obligated to comply with Council decisions. Therefore, decisions by the UN Security Council are considered legally binding. Quote, under Chapter 7, the Council can take measures to enforce its decisions and ensure that mandates are fulfilled. The Security Council can impose economic sanctions or order an arms embargo. And on rare occasions, the Council has authorized member states to use all necessary means, including collective military action, to see that its decisions are carried out. All member states are obligated under the UN Charter to carry out the Security Council's decision. Now, although the world is remarkably united about Russia's war against Ukraine, it will still be difficult, if not impossible, for the Security Council to take direct action against Russia. Most Security Council decisions require a majority of the 9 members plus consent of all 5 permanent member states. Russia, a permanent member, vetoed a council resolution condemning its attack on Ukraine. China and India and the United Arab Emirates abstained from that vote. But you can imagine that as long as Russia is a member of the UN Security Council, no resolution is going to pass. Though I will say there is an interesting legal movement gaining some traction which says that Russia is in fact not a member of the UN Security Council. Effectively, the argument goes like this. The original member of the UN Security Council was the Soviet Union, and the Soviet Union collapsed. Though it was succeeded by the Russian Federation, Russia just assumed that it took over the spot that was originally created for the USSR. So some argue that without formalizing this relationship with Russia, Russia does not hold the seat that the former Soviet Union held on the Security Council. This seems a little bit far-fetched, but we'll see if it gains traction in the future. But let's take a moment to talk about the use of force under international law. After the devastation of 2 world wars, the United Nations was born. The UN Charter established a prohibition on the use of force to resolve disputes among states. Article 2, Section 4 of the Charter bans the threat or use of force, 1, against the territorial integrity of a state, 2, against the political independence of a state, and 3, in any other manner inconsistent with the purposes of the UN. Now, with that said, there are 2 exceptions to the prohibition on the use of force. The Security Council can use force on behalf of the UN to maintain peace and security. A member state can also use self-defense to repel an armed attack. Chapter 7 of the UN Charter establishes that force may be used to keep the peace if the Security Council determines that there is the existence of a threat to the peace, a breach of the peace, or an act of aggression, and efforts to address the matter using measures short of force have failed or would be futile. Now, in the early days of the UN, the Charter suggested that all member states would make their military resources collectively available to the Security Council to use to stop wars. But this has effectively never materialized. And as a result, when the Council needs a peacekeeping force, willing states volunteer their personnel. Putin tried to take advantage of this exception by declaring that his forces were a peacekeeping force. And former President Trump thought this was a great idea and suggested that the US should invade Mexico with fake peacekeeping forces as well. Of course, this is not what peacekeeping means. Under the UN Charter, as one source put it, the Security Council takes the lead in determining the existence of a threat to the peace or an act of aggression. It calls upon the parties to a dispute to settle it by peaceful means and recommends methods of adjustment or terms of settlement. Under Chapter 7 of the UN Charter, the Security Council can take enforcement measures to maintain or restore international peace and security. Such measures range from economic sanctions to international military action. The Council also establishes UN peacekeeping operations and special political missions. Now, additionally, Article 51 of the UN Charter provides for self-defense. Quote, "Nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations until the Security Council has taken measures necessary to maintain international peace and security." A sovereign nation's right of self-defense predates international organizations, and it's one of the fundamental principles of state sovereignty. And as part of this right, nations can rescue their own citizens who are trapped or being held in another country, but a nation can't claim it's merely protecting its own citizens if its real aim is to overthrow a foreign government. Now, Russian President Putin said that people in the Donbas republics sought Russia's help, and that qualifies as self-defense. But Article 51 applies to states, not to individuals. So as of now, Russia is the only state that has recognized the two Donbas republics as their own nations, though this claim appears to be pretext for invasion. And although Putin claims that the Ukrainians are committing genocide in the Donbas, this also appears to be a pretext as well. And Russia also claims that Ukraine is the aggressor here, but even after the invasion of Crimea, Ukraine did not invade or really even threaten Russia. So is the war in Ukraine illegal under international law? Well, yes, but the principle that war is illegal is only as strong as the international community's willingness to intervene in the conflict. And the first modern attempt to make war illegal was in 1928 when the US and France created the Kellogg-Briand Pact, where dozens of countries joined the treaty, which called on nations to settle their disputes peacefully. This treaty was only as good as its members' commitment to it. And of course, the pact meant nothing when World War II erupted a decade later. The world tried again in 1949 with the Geneva Conventions. The Geneva Conventions govern how civilians, prisoners of war, and soldiers are treated. You've probably heard that the Geneva Conventions prohibit nations from torturing people or using torture to extract information. And effectively, all nations have joined the Geneva Conventions, but these treaties only govern how people are treated during war. They don't say anything about the legality of the war itself. And even though the Security Council actions are said to be binding, they're only binding if the Council actually chooses to enforce them. For example, the Iran-Iraq War in the 1980s clearly violated the laws of war, but the Security Council took no steps to intervene. And then finally, perhaps most importantly, there is the International Criminal Court. Now, the ICC is an independent judicial institution that was established in 2002. It is empowered to investigate and prosecute war crimes, crimes against humanity, genocide, and the crime of aggression. 123 countries are ICC members, which means that these countries have given the ICC the authority to investigate and prosecute crimes committed by their nations or by anyone on their territory. The ICC doesn't have the power over countries that aren't a party to the treaty, however. And the US, for example, did not join the ICC. President Clinton signed the Rome Statute, the treaty authorizing the ICC, but the Senate wouldn't ratify it. And President George W. Bush then unsigned the treaty, informing the UN that America did not recognize any obligations under the ICC. Nevertheless, US citizens can still be prosecuted for committing war crimes if it happens in a territory that is an ICC member. Afghanistan, for example, is a party to the ICC and can request that the ICC investigate Americans for committing war crimes. But at the same time, the ICC cannot override the laws of any sovereign nation. It only exercises its jurisdiction when a country is either unwilling or genuinely unable to investigate and prosecute war crimes. And of course, countries are free to prosecute war crimes in their own courts. Though that being said, neither Russia nor Ukraine have signed or adopted the Rome Treaty and are not members of the ICC. So Russia cannot be prosecuted for the crime of aggression. However, in 2014, after Russia annexed Crimea, Ukraine submitted a declaration giving the ICC jurisdiction for crimes committed anytime on its property after February 2014. So Ukraine can ask that ICC prosecutors open a full investigation into Russia's actions. Now, I know when we cover international law, it often feels like there's nothing that we can do, but that's not true. And in fact, if you'd like to do some good for this world, especially regarding Ukraine, I'd recommend Tab for a Cause, which is helpfully sponsoring this video. Now, Tab for a Cause lets you raise money for charity just by opening tabs and browsing the internet, which we were probably going to do anyway. And in fact, Tab for a Cause responded to your request, and they have an entire Ukraine-specific page geared towards providing essential services and supplies to Ukrainian families. And in fact, Save the Children has been providing ongoing humanitarian aid in Ukraine since 2014 and will continue to support families even if, fingers crossed, the conflict ends soon. Now, Tab for a Cause is a Google Chrome extension that allows you to pick the charity of your choice, and then every time you open up a new tab, instead of displaying a blank page, it displays a beautiful new customized tab with a couple of tiny ads. Now, the money that you generate through those open pages is then donated to your charity. Tab for a Cause has partnered with Save the Children, which is mobilizing now for the Ukrainian people. And Tab for a Cause's finances are completely transparent. You can see for yourself how much money they've raised every quarter and where that money has gone. And believe it or not, the Legal Eagles, the people like you who are watching my videos, have already raised over $35,000 alone for charity just by opening tabs, and I'm really thankful for that. So all you have to do is click on the link that's on screen right now or in the description and install the Chrome extension. That's it. Every page you open will create revenue that goes to charity, and it's completely free. Tab for a Cause users like you have raised millions of dollars, and it's the easiest possible way to donate to charity. So just click on the link below and download the extension, and do some good by doing what you were gonna do anyway. So click on that link, or I'll see you in court.